Funding for This Is Nashville comes from you, our listeners, and Amazon, proud sponsor of WPLN's daily show, This Is Nashville, engaging our differences so we can discover our unity. More on Amazon's community work at aboutamazon.com.
I'm Khalil Ekalona, and this is Nashville. Just before Independence Day, the United States Supreme Court issued a decision that changed the very foundations of the executive branch, the office of the presidency, and our democracy. The decision gives whomever currently holds the presidency and former presidents broad immunity, rendering it practically impossible for anyone who abuses the vast powers that come with the office to face criminal prosecution. In essence, the president is now above the law in some circumstances. In elementary, middle, and high school, we were taught about the three branches of government: the legislative, judicial, and executive branches. Each respectively have specific duties they must perform and principles they're tasked to uphold. These branches were meant to establish a checks and balances system to prevent any branch from becoming too powerful. The legislative branch creates and passes laws. The judicial branch interprets the law. The executive carries out the laws. In order for the system to work, each branch must have equal power. However, the decision by the Supreme Court to give the office of the presidency sweeping and seemingly convoluted immunity means that the current or future president is essentially above reproach, clear of any consequences for their actions. This is not the case for you and me. It's not the system that we learned about when we were in school. Many critics and legal scholars are saying this is not what the framers envisioned or intended when they created the Constitution. I want to steer clear of any fear-mongering or wild speculation. None of us know what the future holds. But we can look at current conditions, as well as the status of our democracy, for any loopholes, loose ends, spots of vulnerability that could break what some say is currently a weak foundation. So, we're going to examine not only the recent Supreme Court decision, but our democracy as well. We're going to look at it as American citizens and not through any sort of partisan lens. The only side I'm taking is for democracy to become stronger and more unified than what it is today and what it has been through my lifetime. We're going to begin by examining and understanding the decision by the Supreme Court, and we've invited legal scholars to help us break it down, to get our hands on it and see how this works. See its potential benefits as well as its flaws. We'll break it all down from legalese to layperson's terms so that all of us can not only understand it, but engage in conversations with each other about a change to a pillar of our country's government apparatus. We're inviting you to take part in the conversation with us. Yes, we want to hear your voices. We want to hear your thoughts on our democracy and the powers of the presidency. So give us a call at 615-760-2000. That's 615-760-2000. All right, today we have Dr. John R. Weil. He is Dean of the MTSU Honors College and a professor of political science. And we've got Junaid Odubeko, who is an attorney with Bradley Law Firm, adjunct professor of campaign finance and elections law at Vanderbilt University Law School, and he served as legal counsel to Governor Phil Bredesen. I want to thank you both for being with us, gentlemen. Welcome to This Is Nashville.
It's great to be here.
Same here.
Okay, so I want to give a brief summary of the Supreme Court's decision. This is from scotusblog.org. They offer independent news and analysis on the Supreme Court, and it's rather brief. The summary reads, quote, "The nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. He's also entitled to at least presumptive immunity from prosecution for his official acts. There is no immunity for unofficial acts," end quote. Dr. Weil, what was your first impression after reading the ruling?
I was sort of surprised. You know, this case had been in a district court and an appellate court before it got there. Neither of them had accepted presidential immunity in criminal cases. I had read both decisions and thought they were fairly solid, so I was surprised at the outcome.
Okay. Junaid.
I was surprised, but not shocked. I listened to the oral argument before the court. I also looked at the calendar, as each day went by and we didn't get a ruling from the court. I knew that they were or I suspected they were up to something. I just didn't know the scope of it. The decision by the court is interesting to me. It seems to me that the court both decided way too much and then entirely too little at the same time. A principle of judicial decision making is judicial restraint and deciding the case before you. And here, from what is thought to be a very conservative court, you have an opinion that kind of really reaches to decide issues that weren't necessarily before the court in terms of defining the scope of what this presidential immunity should look like and what it should be for the rest of our country, setting forth very broad terms and standards, but at the same time, not deciding the case that was actually before it, that had a factual record before it, which could have easily have been handled by the court in a very limited decision in its opinion, as opposed to a more expansive decision, which is the direction they chose to go.
You said they went too far and yet not far enough.
Correct.
In some cases. Can you break that down for the layperson? What does that mean?
Absolutely. I think everybody's familiar with kind of the facts of how the case got before the court, right? You had the 2020 election. Former President Trump took issue with it, thought that he was the actual winner. He took several specific actions with respect to talking to his acting attorney general about sending letters to different states, trying to get them to launch election fraud probes. He lobbied the vice president to not certify the election. He gave the infamous January 6th speech at the Ellipses. He had other conversations with other actors about the overturning the election result. So that was the factual record before the court, a very clear record on specific actions the former president had done. And those were the actions for which he was indicted by a federal prosecutor. The court decided too much and too little. The court could have resolved this case just purely on those specific actions that were before it. They could have said, you know what? We don't know what presidential immunity should be 100 years from now. We maybe should take this on a case-by-case basis. Mm-hmm. But here in this case before us, we have specific things, and we can say, look, this looks like an official act, or this is an official action of the president. This is not an official action of the president. And based off of this conduct in this case right here, we think that presidential immunity either applies or it doesn't. But the court chose not to do that, which I think was way too little because it had a record from which it could have made that decision. Mm-hmm. It instead went into a direction where it felt it needed to say what presidential immunity looks like in an amorphous way for the rest of the future of the country and apply it to cases that have not yet come before the court. So it's a wildly expansive take on presidential immunity while not handling the case that's actually before it.
Okay, so Dr. Vial, hearing that, one thing I've heard when I doing research on this and talking to our producers, and particularly like as I listen to podcasts and watching the news when they talked about this decision, was something that Junaid brought up, judicial restraint, that the Supreme Court broke all sorts of legal judicial norms in rendering this decision. Can you break that down for us?
Well, the case is unusual in one respect in that if there's anybody on the court who has been particularly solicitous toward the reputation of the court and sort of moderation of the court, it's been John Roberts, the Chief Justice, probably most notably in upholding the Affordable Care Act, 2-3 times, I guess, total, often against great opposition from his opponents. And in this case, he seems to have put that aside. And, as my colleague has explained, part of the decision, and I guess, he does remind me, I wasn't surprised in the sense that, yes, they took an awful long time. And Trump won. Even if the decision had been different, Trump would have almost won by just waiting this long to make a decision with an election pending. Mm-hmm. And, it doesn't, we're talking a total of 4 or 5 different cases. Civil case, of course, has been resolved. If if this decision doesn't go back and pull some of the evidence from that. But, we got 3 or 4 possible criminal cases, all of which have been effectively delayed. And so that is, it seems as though maybe it was unintentional, but the delay itself seems to be putting the thumb on the scale of supporting Trump or, of avoiding this.
If you're just tuning in, this is Nashville, and I'm your host, Khalil Ekalona. We're talking this hour about presidential power and immunity. My guests are legal scholars Dr. John R. Weil and Junaid Odubeko. We want to hear from you, so give us a call, 615-760-2000, 615-760-2000. If the phone is ringing, please let it keep ringing. We are going to take your call. Okay, so there is a distinction between official acts that a president can take and unofficial acts. Official acts are rendered absolute immunity. Unofficial acts, it's kind of nebulous, partial immunity to absolutely no immunity for these cases, as you mentioned, Junaid, which have yet to come before the court. Can either one of you explain to us what an official act of the presidency is?
Oh, yeah. I'll take it within the framework of the court's decision. According to the court, one of the allegations in the indictment was that President Trump talked to his then acting attorney general about launching some type of federal investigation of state election fraud or trying to get the states to do that. The court considers that an official act because its view is that actions that are within the president's core constitutional powers are official acts. So the president's core constitutional powers are, control of the Department of Justice, issuing pardons, issuing vetoes, faithfully executing the laws of the country. Those are official powers. Obviously, it gets murky when you start saying, okay, well, what falls outside of that perimeter? And to be specific to this case, if the president is acting as a candidate for office, I would think, and I think the court seems to suggest that that's unofficial conduct. So here, when the former president gives his speech at the ellipses and says basically, let's take to the Capitol, is that an official act or an unofficial act? I think most would suggest it should be considered an unofficial act, but you can see the difficulty in trying to ferret it out when the former president, calls the Georgia state election officials and says, find me 11,000 some odd votes. Is he acting as the president or is he acting as a candidate? It's really kind of those, they're inherent in this discussion is some fact finding that the court is basically placing on the plate of future district courts to try to determine, is it official, is it not? But one thing that's important with this decision is, and I think it's kind of one of the big things that doesn't get talked about a lot, is there is a presumption that the president is acting in his official capacity, and the burden is really placed on the indicting official or the charging official to say that the president's conduct is not official, and that's a pretty heavy burden that's for anyone to carry.
Dr. Weil, explain to us the complexities of that burden.
Well, I want to go back to you mentioned listening to the oral arguments, and I forget who asked. It may have been Sotomayor, but one of the justices said something to the effect, what if the president officially tells one of his, Department of Justice or somebody in the Army to go out and assassinate his opponent? Yes, he talked to someone that he'd normally have control over, but to call that an official act, it's just very counter. If your duty is to uphold the law and you're instructing someone to obstruct the law, particularly by the use of violence, and frankly, I don't think the majority opinion ever answered the question. And Sotomayor was questioned or criticized for, she's saying the sky is falling, it's not that bad, but without a specific answer to something that clear, I think there is a problem here. Absolutely.
Yeah, when you don't put guardrails down, you invite skies falling analysis, right?
Yes, so, very much.
Yeah, if the president can have let's say under this opinion, the president can direct the Department of Justice to go investigate a political enemy for some, assumed violation of federal law. he is acting within his core constitutional power to direct the Department of Justice to do this investigation. What if the president concludes that his political enemy is a threat to the country or some type of legitimate executive power that the president, executes? Can the president, instead of investigating, can he just go shoot him? And if so, is that then, if he can rationalize it as, I view this person as a legitimate threat to the country, a legitimate threat to the faithfully executing the laws of the country, this opinion seems to suggest that there is no limitation on let me state this way. This opinion seems to suggest he'd have absolute immunity for taking that action.
Now, Dr. Val, you mentioned Justice Sotomayor's dissent and the reaction that it got from Chief Roberts and Clarence Thomas and others. Yeah,
the dissent or the opinion that I think bridges a little bit of the difference, if I can change, is Amy Coney Barrett, who is, of course, one of Trump's appointees. And she has a little bit more, she's somewhere in between in saying that at the very least, if the president has a conversation with the attorney general that we know about and later his opponent is killed, then we ought to be able to look at what that conversation said. And she's absolutely right on that as far as I can tell. And, it's a 6-3 decision, but on that issue, at least it's 5-4.
Yeah, and just to add a little bit of additional context to that, I think the issue is the court's opinion goes on to say that if it's within the president's core constitutional power, you can't even use that as evidence of a charge in any type of indictment. And that seems, like you said, Professor Val, that just doesn't seem logically to be something that makes sense in that, like, you'd never be able to prove any type of crime or anything against.
I just read a biography of Richard Nixon called something like The Lost Soul. And one of the points it makes is that Nixon was sort of mouth off, and he'd say, well, we ought to fire this person, or we ought to send troops in here. And most of his staff knew that's just Nixon, nothing. But I'm not sure that there were people around Trump when he said something that weren't sure whether he meant it or not. And, Roberts is very concerned about hobbling future presidents. And we need to have an energetic executive. We've already given, there's a previous case, Fitzgerald, Nixon versus Fitzgerald, in which the court declared that there's immunity from civil suits, and that makes sense. President has to make a lot of tough decisions. We have immunity against civil suits in most cases for police officers. They have to make, momentary decisions. Yeah. Often, without a lot of reflection, but we can take it too far. Against energy, you need the principle of accountability.
Okay, we've got a call from Denny in Cool Springs. Denny, thank you so much for calling. We're trying to get Denny through. Denny, hold on a second. We're going to get you through to us in 1 second. But before we go to that call, just want to remind everyone, give us a call, 615-760-2000, 615-760-2000, as we work to understand the recent Supreme Court decision that offers broad sweeping immunity powers to the presidency. Now, Dr. Val, you mentioned Richard Nixon. Today happens to be the 50th anniversary of him stepping down from office after the Watergate investigation and everything else. Okay, we've got Denny. Denny, thank you for calling. What is your comment, my friend?
I'm a retired attorney. I'm 82 years old, and I have read this opinion, and I think it is a travesty of justice. It's no one is above the law. That is a principle that our country.
Oh, Denny, are you with us still?
Yes.
Okay. Sorry. For some reason, our system is doing what it wants to do on this Thursday, but we got you. Continue your comment, my friend.
Okay. I think the historians' brief that was amicus brief that was filed by 15 historians showed clearly that there was no intention on the part of the founding fathers to grant the president any kind of immunity from criminal liability. The principle that no one is above the law should be a principle that every lawyer and every judge should abide by. Okay. In 1984, I sued a judge in Nashville, Judge Everett, who was a probate court judge, for violating a lady's civil rights. And I argued the case before the U.S. District Court for the Middle District of Tennessee. And I had on my opposing me on the question of judicial immunity. I had the former Attorney General and the former U.S. Attorney. And the court held that the conduct of the judge, in part, was outside his judicial role, and he could be sued and held liable. And I think that was one of the highlights of my career. I've retired now. I'm 82 years old. And I think that, but when I was asked that in my oral history that I gave to the bar, why did you do that? And I said, because I believe no one is above the law. And I believe every lawyer and judge should abide by that principle. They've taken an oath to support the Constitution, and the Constitution does not give anyone the right to have criminal immunity, such as the president and the court, the six-person majority on the court that decided Trump versus United States. They did not find any language in the Constitution to support their just declaration that the president, in certain circumstances, when he's acting in his official role or whatever, that he has criminal immunity. Mm-hmm. None of the founding fathers and actually no president before Trump took the position. Maybe, I guess, Nixon did when he said, if the president does it, it's not illegal. But he resigned, and I think he did at least concede that he did not have immunity. And I think that the court has shown itself to be a highly partisan court, those six members, because obviously this ruling was made for Trump, because it was made at a time when he was facing, he had been indicted for four criminal cases, two of which at least were federal charges. And obviously the court showed its partisanship and its unwillingness to follow the language of the Constitution.
I want to thank you so much for this comment, for this really good and poignant comment, Danny. Really appreciate it. And so I do want to ask about that before we go to break. I mean, the idea that this country, that the Constitution renders no one above the law. And here we have a lot of people feel like this court is highly partisan, an activist court in many ways. And it's changed the fundamental nature of presidential immunity and presidential power. Briefly, Junaid, what does that mean, and how we have to kind of come to grips with accountability in the highest offices of our country?
It's a really good question. The accountability piece it is just hard to kind of figure out. It's particularly where we're looking at, we're looking at all three branches of government, two or three, or maybe all three are like fundamentally broken at this time. I think it really does kind of highlight the fact that why in the past concepts like precedent and judicial restraint have been important, because those are conservative jurisprudential principles that have gotten the court through a couple hundred years. It's not the first time we've had tricky issues. It's not the first time we've had tricky separation of powers issues. But what we're seeing is, and you hinted at it, is the breakdown in other branches has led to a court that's more susceptible to the partisan whims of one party or of one side, and it's dangerous for what could come.
All right, we're going to take a short break. When we come back, We'll return to your calls. We've got a bunch of them on. If you're on the line, please let it keep ringing. We are going to get to you. We're going to try to understand presidential immunity and where it stands now because of the court's recent Supreme Court decision. Give us a call, 615-760-2000. We'll be right back.
Funding for This Is Nashville comes from you, our listeners, and Music City Prep Clinic, Nashville-based provider for PrEP, and offering comprehensive sexual health services in an environment designed to be safe, professional, and shame-free. Learn more at musiccityprep.org.
I'm Khalil Ekalona, and this is Nashville. We're discussing presidential immunity and presidential powers. The Supreme Court has given the office of the president absolute immunity from criminal prosecution for official acts taken, implied immunity for other actions. In some cases, this will render the president above the law. Some say it makes the president a king of sorts. What do you have to say about it, and what are your thoughts? You can call us at 615-760-2000 to share a comment or question with our panel of experts. They are Dr. John R. Vile and Junaid Odubeko. Again, the number is 615-760-2000. We have a call from Lisa in Brentwood. Lisa, thank you for calling. What's your comment?
Hi, thank you for taking my call. So it partially comment and partially question. This has been referred to, I'm not an expert, but having read so many legal scholars talking about the vague language in the decision that then leaves it open to interpretation. And that's a concern. But I think we are looking at it from the legal perspective as opposed to the practical perspective. And I think my question is, if the president, whoever the president may be, decides that they want to enact or act in some capacity that is they consider official capacity, right, which is what the immunity says, if they're acting in official capacity, what does that mean for everyday citizens? Because if I don't know, I could give an example. There's a peaceful protest and it's on an issue that whoever's president doesn't like, and they call out the National Guard and tell them, fine, shoot the protesters. What does that actually mean? Because we can't possibly imagine all the scenarios where this would apply. So as a regular citizen, where do we stand on that? What happens to us?
Thank you for that great question, Lisa.
Well, a lot will depend on the character of who's in the presidential office. We talked about guardrails, and guardrails are there for people who need them. Not everybody, but the founders were very, they believed that power corrupts, absolute power corrupts absolutely. And this does open the door to a president who, may not have the character to act in the best interests of the country.
We're going to go to Wilson, who's got a comment. Wilson in Nashville, thank you for calling. What's your comment?
Yes, thank you all for taking my call. I'm not a constitutional lawyer, but I was trained as a historian, and just from my perspective, I would have to think the framers would be not only appalled by this, but wanting to take action. I think we sometimes lose sight of the fact that they were part of a revolutionary generation that were unafraid to advocate taking up arms against what they regarded as tyranny. And you read the Federalist Papers, they were very worried about somebody who would be a demagogue and do the kind of things Donald Trump did without accountability. I think they not only would condemn the decision, but I think they would call for the structure to be overturned. They would be willing to take up arms over this. And that's the comment I wanted to toss to you all.
All right. Thank you so much. Response to his comment, anyone?
Yeah, it's the need for this opinion is really in question, right? We made it well over 200 years as a country without having to extend this type of broad presidential immunity. It does seem to run contrary to the notion that this country was founded because we didn't want a king. So to look, some 200 some odd years later, and we've bestowed royal powers on the executive, belies kind of the part of the reason for the founding.
And there have been some proposals to overturn the decision by constitutional amendment. That's a difficult process. I think it's, what would be interesting if Harris is elected. Most presidents get 2 appointments. Biden did not. But if you had two people on the court, and this was one of the reasons that they were selected, you could have, the court's not likely to overturn it that quickly, but certainly modify it to some degree.
But does that lean towards having more partisanship in the Supreme Court? That was supposed to be the one place where partisanship did not exist. At least that's how it was explained to me from second grade all the way through my political science degree in college.
Part of what's happened here, the court's always been a political body, but it got accentuated in the fact that in Trump's last year, there was a confirmation. Well, the last year of Obama, a confirmation was blocked that then went to Trump. And then in the last year of the Trump administration, an appointment was pushed through that normally it certainly would not have been pushed through if you'd used the same thing. So it's a little out of whack because of that.
Yeah, I would say I totally agree with Professor Weil. The courts, there's always been a level of politics in the court. It's just been the least political of the 3 bodies. Even if you go back to Marbury versus Madison, that was a political decision saying that the court would be the arbiter of these interpretation questions. I hate to say this, but the notion of divorcing kind of partisan politics from judicial politics, that horse kind of left the barn back in the mid-'80s with the Robert Bork appointment, and we've been on a spiral ever since. And you see it all around. You see it. It used to be presidential Supreme Court nominees were usually approved by massive numbers, and now it's basically party line votes. You might have one person on each side of the other. So, again, the court's fallen prey to some of the partisanship in the other branches, and until we kind of clean that up, I don't know how to fix it. Now, there are some interesting proposals out there in terms of President Biden had a proposal for 18-year terms, and I think it's things that warrant a legitimate discussion and conversation about what we do, because don't know that the notion of lifetime appointment and anymore makes sense. The system's been totally gamed by people appointing, 40-some-odd-year-olds to the court, and they're there for, 40 years. And so judicial reform's worth discussing.
If you're just tuning in, this is Nashville, and I'm your host, Khalil Ekulona. We're talking this hour about presidential power and immunity. My guests are legal scholars Dr. John R. Weil and Junaid Odubeko. All right, we want to hear from you, so give us a call, 615-760-2000, 615-760-2000. We got Joe in Nashville. Joe, thank you for calling. What's your comment, my friend? Joe, hello, Joe. Hey, Joe.
Hello.
Hey.
Hello. Sorry about that.
That's all right.
Hey, thank you so much for taking my call. And I'm so glad you're getting into the political part of the court. And I think this is really just pure triumphalism. And it's no different really than the Dobbs decision in my mind. But I think it goes back to Nixon, interestingly, through Roger Ailes. Roger Ailes was a political consultant to Nixon. And he said, if you had your own network to counter CBS, you wouldn't be in all this trouble. And I think Fox News that he created, this is a toxic side effect of it. It's created an us versus them, where you can have 2 Supreme Court justices that are basically, it's a middle finger to ethics. One of them, his wife is an activist on one side of the political spectrum, and the idea of, recusing yourself in a court case just seems to be inconceivable, much less ethics reform. So I think it's really a deeper issue, and it's a problem with our politics. And, you have one network that's just a pure propaganda network for one side of the argument. So I'll let you comment on that, but thank you.
In early America, they had what was called the party press. And if you were a Federalist, you read certain newspapers, and if you were a Democratic Republican, you read the other. And it has become very much like that. In the case of Fox News, they actually lost what is it, $745 million? I mean, it was a chunk of change.
Over the Dominion vote
right, over
case.
Allegations, false allegations about a company, and it doesn't seem to have one iota of effect on the audience. The audience continued. It's ironic.
I have a question. I'm thinking, has history shown us that presidents have always been a little bit above the law? Have presidents always found ways to kind of chip away at the restrictions of the office?
History shows us that, the president, I think functionally, as our system was set up, the president is it's the branch of government that can take quick action and can take bold and decisive action, right? That's why the president has the power under the Constitution to declare war. Well, I guess Congress has the power to declare war, but the president, carries out all military actions. When we need something to happen fast, we charge that with the president because we don't have to get a majority of 435 members of the House and 100 members of the Senate to approve it. And presidents have always pushed for a maximalist view of the executive. I don't know a president who said I ought to have less power or less of an ability to do something, because I think presidents oftentimes get frustrated by having to deal with Congress, having to deal with the federal bureaucracy. They've been elected, they have a mandate and agenda, and they're trying to push it through, and they want the kind of maximum power that they can to do that. We've never confronted issues where, and again, getting back to the problem with the Supreme Court's opinion, it sees this world where every president is subject to criminal prosecution after they leave office, and that's not the world that we've lived in, and there's really no indication that things are going that way. And so it's why this opinion was really kind of an overstep.
All right, we got one last call from Jerry in Nashville. We're going to take this call, and then we're going to go to break. Jerry, what's your comment, my friend?
Yes, I just like to make the comment that when they made that law, when they passed that law about the president having broad immunity, they paid Trump back for everything that he had done to get them on the courts and to put him in power, that if he is elected, he would go straight into dictatorship. And he's did everything that a public official could possibly do and just slide through. But if he gets in office, he will go to dictatorship and will change that Constitution to where he would probably never get out of office. And that's my comment, and I'll hang up and listen.
All right. Thank you very much for that, Jerry. And now I understand what he's saying. A lot of people have those fears of former President Trump, should he take office again, becoming a dictator, kind of ending our democracy in full. The Democrats are running on that campaign. But to put it outside of Trump versus Harris or anything regarding the 2024 general election, this is something that we have to consider. It could be a potential Democratic candidate 20 years in the future who decides to act in this manner. What are the potential ramifications of this decision, and what do we have to be looking out for?
May I make a comment? It was interesting in the last day or two. When Trump ran, the crowds would say, "Lock her up." And he would, yes, lock her up, lock her up. Now, when he became president, he backed away a little bit from that. But when Kamala Harris, when they started saying lock him up, she basically said, this is a matter for the courts. This is not an executive decision that should be made. And I think that's probably the right balance here.
So y'all have been playing the theme from The West Wing, coming in and out of breaks. And I'm reminded of the debate episode between President Bartlett and Governor Ritchie, in which there was a line in that episode where President Bartlett says, when you're president, there are a few days that end, I'm paraphrasing, that involve a few issues that involve a clear right and a clear wrong. And most of those days usually end in a body count. I'd say that to say the job of president is really complex and it's difficult, and you're facing decisions that no one else in the world has to face. The issue with this decision is I don't think that, next year or a few months from now you'll have a president just kind of wildly breaking the law without fear of any consequence. But what does happen 20 years ago? The abuse of power is like erosion. It just, over time, it just grows and grows and grows. And I might not be able to imagine that next year, 50 years from now, after 50 years of erosion, 50 years of a president feeling like all of those decisions that are in the gray area, if I just take a couple steps over the line, I'm not going to face any consequence for it. What happens down the road?
Mm-hmm. And the irony is the court claims to be looking toward the future.
Yeah.
And they seem to be ignoring what's happening right in front of them.
Absolutely.
There's a lot for us to still figure out. All right, we're taking one last quick break. When we come back, we'll look at immunity for state and local officials. Do they possess the powers that the president does? Give us a call, 615-760-2000. We'll be right back. I'm Khalil Ekalona, and this is Nashville. We've been discussing presidential powers and immunity, where a line of accountability was originally drawn by the framers of the Constitution, and how, due to a recent Supreme Court decision, that line of accountability continues to be redrawn. But what of our state and local elected officials? Does the governor have broad immunity powers? What about state representatives? Still with us are Dr. John R. Weil and Junaid Odubeko. Thank you both for being with us. They're legal scholars and they know what they're talking about. Okay, so if you want to make a call to talk about this with us, give us a call, 615-760-2000, because we do want to hear from you. So I do have this question. How does immunity work at the state and local levels? Is it similar to presidential immunity?
I'll chime in. So, yes and no. It is similar in that local governments and state governments do have broad grants of immunity from which they work in. People maybe heard the term sovereign immunity. It's this notion that came over with us from England. It's this notion that you can't sue the king, okay, unless the king says you can sue him. And every state has sovereign immunity. Now, states have passed governmental tort liability acts, and Tennessee has passed one back in the 70s that says, okay, in these limited situations, I'll let you sue me. So if someone's driving a state truck and they get into a car wreck with someone, by law, you can sue the state then. But you can't sue the state for everything. So each state has different exceptions for when you can sue them. Now, to touch, and that extends to local governments too. There's a thing called governmental immunity, and that's really qualified immunity. We talk about that a lot in police officer shooting cases. Mm-hmm. And then there's absolute immunity for a Metro Council person acting within the discharge of their duties. In Tennessee, criminal activity is not an exception to the Tennessee Governmental Tort Liability Act. So if unlike what we have seen with this Supreme Court decision, if you act criminally, that's not protected conduct. What will be interesting to see now is if, because of this decision, you now see a rash of absolute immunity cases for governors, for executives go through the states and the local governments, because it's now been recognized on the federal level.
Mm-hmm. Now, does this? I just have this question about our state legislators and what have you. This idea of immunity. We're talking about criminal cases, not civil. So they're immune when it comes to civil cases out there.
Go ahead, President.
I was going to say, in civil immunity cases, the government itself might not be immune. If a police officer does something wrong, you might have a civil suit that the state would pay for rather than the police officer himself.
That's right. The individual. Okay. So does the city, the mayor, Metro Council members, they enjoy a certain level of immunity you were alluding to, Junaid?
Again, acting within their official capacity, performing their official duties, they do.
Okay.
You know, there's a fascinating case right now, the Menendez case. Of course, he's been convicted of bribery, the New Jersey senator.
Bob Menendez,
but,
yes.
you know, there's a provision in the Constitution that says you can't be questioned for anything you said on the floor of the Congress. And they actually excluded some testimony on the basis that, you know, evidence on the basis that it was secured illegally. So it's sort of an unintended consequence of something designed to protect freedom of speech.
Yeah, it's. I think the extension of that is you also can't be sued for votes that you take, because the lawmakers all feel free to be able to engage in public discussion, debate, and take votes without fear of being sued.
Okay.
Yes.
All right. We're going to take a call from Joe. Joe, I mean, he might be leaning away from local immunity, but talking about national immunity. Joe, thank you so much for calling. What's your comment, my friend?
Yeah, thank you. Just quickly, for me, I understand that judges, local officials, the president, everyone has an umbrella of protection. I think most would agree with that. Mm-hmm. So I guess the issue is, how far does that level of immunity go? Reference this umbrella of protection. And reasonably, a judge normally can't be charged unless there's malicious intent shown. And everything works that way. So why is there this absolute immunity issue, an all of none situation here?
Thank you for calling, Joe. Doc.
I think some of us think there shouldn't be. I don't think. I mean, I think the president should have wide latitude for policy matters, but I don't think the president or anyone else should be above the law, particularly in matters related to criminal law.
All right. We got a call from Larry in Nashville. Larry, thank you for holding as long as you have. What's your comment, my friend?
Hi, this is Larry from Nashville. Well, first of all, I think we have to go back to who wants immunity. I don't think that anyone that tried to overtake the government illegally should be granted immunity, because that's not a foundation that you could build on. What about the moral responsibility that's apparent here?
Thank you so much for that comment. And that's a good question. Where does morality and legality, where do they merge, and where should those things be held separate, if at all?
I will say one of the critiques of the court, the Supreme Court, in this immunity decision is, and again, it gets back to the whole deciding too much and too little at the same time, is that there's this notion that the arguments put forth by former President Trump and his lawyers weren't really good faith arguments, and that a court ought to be able to say, okay, based off the facts, the factual record, the fact that there was like an attempted coup, that these aren't really good faith legal arguments that you're making before us, and could have decided the case on that basis.
And there was a recent decision that basically said that on Judge Chutkan's recent decision on right. Trump, that you haven't presented any evidence. You just seem to be wanting more delay.
So I got about 2 minutes left, not enough time to take a call. But let me ask you both this. Here we are seeing probably the most unprecedented, definitely the most unusual general election cycle of my lifetime. I'm sure of both of yours as well, and many of our listeners. We have listeners who are supportive of the Democrats. We have listeners who are supportive of Republican Party. How can we take this information, this discussion that we have now, and have in the future, our listeners create fruitful conversations with each other and people who don't believe politically the same things that they do, to where we can look and strengthen our democracy no matter who wins the office of the presidency or takes control of Congress? Dr. Vahl.
Well, the beauty of elections, if we continue them, is that you have only 4 years of presidency, and then there's another decision. And each party has a vested interest in seeing that the electoral system continues. And no party, in my judgment, has a vested interest in putting anybody above the law.
Totally agree with that. I also think that functionally, how do we want our democracy to work? If you take partisanship aside, the question you have to ask yourself is, or even if you reinsert partisanship, do you want the other party to have this type of power? Mm-hmm. And if you can't answer that question in the affirmative, then you really need to step back and think about it. I also think that in these discussions, when we talk about functionally, how should our three branches of government work? I would argue we're here today, and we're here for a lot of troubling reasons because Congress is broken. Yes. It's the first article in the Constitution. It is wholly broken. It's created issues with the court, issues in the executive branch, and, kind of all across the country, and that needs to be fixed first.
Well, this is something that we're going to continue to talk about on Thursdays, and we're going to get calls from you, our listeners, so get ready. Every Thursday, we're going to be talking about our democracy, and we want to hear your words as you get to talk to experts like our guests today. We are very grateful for having you both. Dr. John R. Vile, he is the Dean of MTSU Honors College and a professor of political science, and Junaid Odubeko, who is an attorney with Bradley Law Firm, adjunct professor of campaign finance and elections law at Vanderbilt University Law School, and he's also served as counsel to former Governor Phil Bredesen. Again, gentlemen, thank you so much for explaining this to us. Really, really deeply appreciate it. Thank you.
Thank you.
Good to be here.
All right. And thanks to you for tuning in this hour. This is Nashville. It's a production of Nashville Public Radio. Today's episode was produced by Mary Mancini. It was directed by Tasha A.F. Lemley. Our technical director and board operator is Liv Lombardi. Catherine CC's was on the phones. Masterminds behind our theme music are Laurent and Namir Blade. Listen back at thisisnashville.org or wherever you get good podcasts. The conversation never ends here. Tweet us at This Is Nashville. Find us on Instagram. Tell us what you want from our quick survey. You can also call to leave us a message. 615-751-2500. But keep in mind, all messages you send to us in the box may be used on the show. This is Nashville. I'm Khalil Ekalona. We'll see you tomorrow, everybody, and be really good to each other.